Hello, everyone. It is actually 7 o'clock on the dot Eastern Standard Time. Folks are walking into the Zoom space, so please welcome, come in, hope you grab a seat, have a snack and some water. It's been, I know for me, a rough couple of days, so I hope you're taking care of yourself. We're gonna have a really interesting, I think, informative conversation. I know that I'm gonna learn a lot, and that's why I really enjoy us doing these digital roundtables. So I'm gonna give folks a couple of minutes to come in. As you enter into the Zoom room, please feel free to drop your name and your location so we know who's with us this evening. We'll have an amazing panel conversation. We'll also make sure to have some time at the end for questions. But as we're in the midst of the conversation, please feel free to drop questions in the chat and we will try to bring them up as is relevant with our conversation. But just really want to thank folks for joining us. So I'm gonna give it another minute or two for folks to come in. If you're a regular at the Demand Justice digital roundtables, you know, sometimes we don't start right on time because sometimes our guests are not as punctual as our guests are today. So it's really exciting to be here together right now. So thank you all. Yay, thank you all for dropping where you're from and who you are in the chat. I was really glad to have you here with us this evening. So I'm gonna go ahead and get started because I think we have a really juicy conversation and I want us to have as much time to do that. And so just so folks know who I am, my name is Tamara Brummer. I am the Senior Advisor and Director of National Outreach and Engagement here at Demand Justice. And I just want to say again that I hope that in the midst of the most recent tragedy in Texas, that you are finding a little bit of light in this moment and also a little bit of hope so that we keep fighting together for the country that we all know that we want and deserve. The conversation this evening, we're going to be talking about two cases that the Supreme Court will consider this fall that could upend decades of precedent on the value of diversity in higher education and how we can achieve that diversity. I want to start by thanking our partners, Asian Americans Advancing Justice, Latino Justice PRLDF, and Lawyers Committee for Civil Rights Under Law for joining us tonight. I think we're, can't say this enough, but we're just so very lucky and thankful to have you all along in this fight and as a part of this conversation this evening. Before we get to our panel, I want to give a bit of context and background about the cases and why we're discussing them this evening. The Supreme Court has, for 4 decades, that's 40 years, consistently held that diversity in higher education is a compelling government interest and that the government should consider these things. It should use race, as one of the many factors they consider in their admissions decisions. But this fall, the court will hear arguments in 2 cases that seek to undo the 40-year precedent. These are just the most recent attempts in a long line of cases that seek to hinder the ability of institutions of higher education to diversify their student bodies. So although Brown versus Board of Education was decided nearly 70 years ago, let's be clear, we know that schools in this country remain severely segregated by race. Affirmative action and diversity programs in colleges and universities are essential to expanding opportunities to all communities and ensuring a rich diversity of experience for all students. All students in our communities benefit from being educated in a diverse and inclusive classroom. Diversity is essential to ending systematic racism and structural inequality. It's also critical to every student's future success in an increasingly diverse and changing world. The court's rulings in these cases could have immediate and devastating effects in education and beyond. Furthermore, these cases come at a very perilous time in our country. Violence against communities of color has surged in recent years, making obvious what we have known all along, that discrimination is violent, and if it's allowed to persist, it can be deadly. Less than 1 week ago today, we lost 10 lives in Buffalo, New York because of racism and white supremacy. But we see it so often, it's becoming almost numbing. Last year it was in Atlanta, 2 years ago it was in El Paso. These are just a few recent examples and are very unlikely to be the last, unfortunately. But the Supreme Court itself is in the midst of its own crisis. Over the past few years, the court has rapidly lost the trust of the American people it serves. The court's approval rating is down to 40%. That's the lowest it's been in a decade, and it's fallen nearly 10% since July. Many of us are losing faith, but also some of us are losing our lives because the court seems more and more willing to act as another political branch and to overturn longstanding precedents and to reach political ends that the justices themselves favor. Our faith in the court was certainly shaken when 3 weeks ago a draft opinion leaked that would overturn Roe v. Wade. A decision to overturn 40 years of precedent and prevent schools from implementing affirmative action plans would similarly shake the faith in this court. Obviously, there's a lot at stake in this case, so I want to get to the conversation. I want to start with our real experts, our panelists. So I want to introduce our guests this evening. First, we have Eri Andriola, who's the litigation staff attorney at Asian Americans Advancing Justice. We have David Inosa, Director of Education Opportunities Project at Lawyers Committee for Civil Rights Under Law, and Nathalia Varela, staff attorney at Latino Justice PRLDEF. If folks want to give our folks a round of applause, make some noise at home, but I'm really excited for the conversation, the folks who we have this evening. So my first question is to you, David. Can you start us off by giving us some background into why we use affirmative action in higher education, what the benefits are, and why diversity in higher education is so important?
All right, sorry, I'm navigating my mute here. All right, well, yeah, I appreciate, the opportunity again, for seeing people, from all across the country listen in. I know there's lots, that people can be doing, and appreciate, this opportunity, one, for demand justice, to put this topic out there because it's incredibly important, and for you all to be listening in. So, first, I think it's important, and I know we're going to get into, how the court examines affirmative action, today, but I do think it's important for people to understand that what today's affirmative action is and what it isn't, right? And how it compares, to basically your mom and pops, or maybe even yours, depending on your age, of what you knew as affirmative action. So it's affirmative action of yesteryear was full of quotas and bonus points and separate admission stacks, that were reviewed. And that type of affirmative action has basically gone away. Today we have, race conscious admissions programs that align more with holistic admissions plans. So what does that mean? That means that all the great things, that students do in high school, their experiences, et cetera, are considered along with their own race. So race is only one factor. It's certainly, meaningful, but it's not a substantial or overwhelming factor. And, that it's not just me saying that, but that's what the evidence and, in these cases show. So why do universities, still consider race? I mean, primarily for two reasons. One, because schools, especially highly selective schools, basically do a poor job of identifying, recruiting, admitting, enrolling, and retaining highly talented students of color. Discrimination and opportunity still exists today in many different forms than compared to what it did yesteryear, but today it still exists. So it still lingers, in the admissions process, in the recruitment process, in the enrollment process, and in the retention process. So, that's primarily, the number one reason, like how and why do you even need to consider race? But it's also important because we recognize that diversity in education, especially racial diversity in education, leads to tremendous academic and social benefits. So what are these benefits? These benefits for an individual might help reduce isolationism, softens the impact of being the spokesperson for one's race. So how many times have you turned your own head towards a person of another race when a topic that might come up on, disparate incarceration rates, or, immigration policies, or rural white poverty that might come up, and you find yourself, and depending on how many, students are in that room, sometimes people feel like they're, the spokespersons in the race. So it helps, reduce that as well. And for all students, it helps break down stereotypes, broadens perspectives, deepens critical thinking, builds cross-racial understanding and friendships. And these benefits are two-way benefits, right? They're not just for one race. They're not just for one group. They help, all the students, acquire, these benefits. And I say that because, Students for Fair Admissions has actually stated in its briefing to the Supreme Court that, and it hasn't, to my knowledge, stated this, quite so succinctly in the past, but now that it's trying to get to a politicized, Supreme Court, hopefully, it's saying that these are only one-way benefits, that only people of color carry, these, it's only that only white students actually benefit from this racial diversity, and almost suggesting, that the burdens are carried, by people of color. And I do want to make clear that these are not theoretical benefits. They're actually in the record in this case. So it's not just research. Certainly that was part of the record in this case. But, these are students and alumni that we represented as interveners in the UNC case, as amici plus status that we shared, in representing with the Asian Americans Advancing Justice amici in the Harvard case. And these are students who talked about, for example, about a future physician, a non-Black person, learned of the incredible barriers to healthcare facing the Black community. They never realized it, and how this would help inform his future work. Another client, who identified as a Black female, testified about her friendship with a white South African who shared about the struggles in overcoming apartheid. What they learn from each other, those experiences are incredibly important. So to get to your last question, why is this important? For all those great reasons that I just said, right? But collectively, racial diversity in education helps prepare students for the 21st century workforce. It creates pathways to leadership, and ultimately it helps build trust in our democracy. These are all important underpinnings of a true democracy that operates in real time to help open up doors of opportunity that are otherwise, unfortunately, closed.
Thank you for that, David. I also think I hear this idea that people, if the way that we're looking at affirmative action is not just about a certain amount of numbers, it's like we're looking at whole people, and that before we weren't looking at the wholeness of people. So we were putting people of color, for instance, in spaces, and that does harm just because they're a person of color, and not thinking about what that means for their own well-being, but the well-being of their white peers as well. So thank you for that breakdown. My next question is for you, Nathalia. The two cases before the court now are just the latest in a 40+ year history of the Supreme Court's consideration of affirmative action in higher education. Can you tell us about the path the issue has taken in the court and where the law now stands?
Sure, absolutely. And I similarly want to thank Demand Justice for this opportunity to be here on this panel. And I'm deeply humbled to be on a panel with Eri and David. So I'm very happy to be here and to discuss such an important topic. I think I would, I'm a big history buff, so I apologize now. But I think I would go back to, Regents University of California v. Bakke. It's a seminal 1978 SCOTUS case. And it was a 414 plurality decision in Bakke. And I kind of want to go through a little bit of the facts with you because I feel like it's telling, and that way I think it gives a lot of ground on where we're going. And then I also would like to identify some trends. So in Bakke, a white medical student applicant challenged the admissions program of the medical school or state medical school, which was designed to assure the admissions of a specified number of students from certain minority groups. So Blacks, Asians, and Mexican Americans. That's how it's identified. And so these are the racial quotas that David was referring to, the racial quotas of the past. And so the school, upon its initiation, so it opens in 1968, has a really small class of 50 students that it admits. And in the first few years, it has 3 Asian Americans that were admitted, and then the rest of the students are white. And then eventually the staff comes together and says that they want to develop like a separate or like a distinct admissions process in order to diversify the classroom, and specifically targeting the idea of minority students to come in. And so eventually with 50 still as the admissions class rate, they allocate 8 slots for minority students. After that, they double the class in size, medical school's doing well, and they up it to 16 spaces. So, I just kind of like to give those numbers because it's like smaller numbers. And I think it's really relevant to, what it means to diversify space. So Alan Bakke is a white medical student. He applies 1 year, doesn't get accepted. He applies a second year and he doesn't get accepted and decides to sue and says that the program that they're offering, or this admissions process that looks at racial quotas, is unconstitutional and it violates his equal protection rights. And so unfortunately the court found, and so I think that one of the big trends, and something that we'll talk about a little bit more, is that this begins the battle for which level of scrutiny these sorts of programs have to go under. And so, Bakke and his legal team argue that this should be strict scrutiny. And the school argues that it should be another level of scrutiny because this is a racially benign program. And so ultimately the program is struck down as unconstitutional. And we find that, and generally, and also they find that strict scrutiny applies. So the idea is that the order to justify the use of a suspect classification of state usually has to show the purpose of the interest is both constitutionally permissible and substantial, and that its use of classification is necessary. So interestingly, the school puts forward four state interests, like that this is their compelling interest for the school, which is reducing the historic deficit of traditionally disfavored minorities in medical schools and in the medical profession. The court finds this facially invalid because it's saying like it's on the basis of just race being race, and that's facially invalid. Also countering the effects of societal discrimination. They say this is a compelling reason, but it's not narrowly tailored enough for their interest. It's too broad, and also that they didn't it's just societal discrimination overall was just not enough to like really make this work. And then I think and then it says that another compelling one that they found was a compelling interest was the increasing the number of physicians who will practice in the communities currently underserved. And they said this was a compelling government interest, that public health is a compelling government interest, which I think everyone in this room, virtual, knows that this is certainly a time where it's very clear when public health is a compelling government interest. But unfortunately, there wasn't enough information in the record. That's what the court decided. Not enough information in the record, and so it's not narrowly tailored, or they're not really sure it's compelling. And the winner of what was compelling, or what they kind of felt like was what they drew on a little bit more, was obtaining the educational benefits that flow from an ethnically diverse student body. It's necessary to decide which, if any of these purposes, is substantial enough to support the use of suspect classification. That's what the court says. And some of the justification around it was the concept of academic freedom. And they put out like 4 different purposes for it. And so like business, this is the university's business. This is like great for how academia works. And ultimately they left it that the program that the medical school was using was unconstitutional. Bakke was admitted because the school couldn't prove that they wouldn't have selected him. But the court did say that the California Medical School had a substantial interest that legitimately may be served by a properly devised admissions program involving the competitive consideration of race and ethnic origin. So I know that was a kind of long intro, but I feel like you may be able to hear some of what David started discussing on the origins of this and sort of how this trend goes on. And I think a lot of people hold on to, like I said, it was a plurality. And so a lot of people hold on to something that Powell said in his like lone wolf opinion, that race or ethnic background may be deemed a plus in a particular applicant's file, yet it does not insulate the individual from comparison with all other candidates for the available seats. So, you know, I think you can hear from there how sort of this is built out. And I would identify that from here, there are two themes that are ongoing and that seem to be in this fight and just a general fight about race around the country. And it's the shift toward a colorblind paradigm that ignores the purpose and the enactment of the 14th Amendment and the Equal Protection Clause. Even when a plan passes constitutional muster, it's to keep pushing away from race. In Grutter and in current cases, race is simply a factor of a factor, or in the case of Fisher, it was race neutral, but simply the racial impact was enough to offend the census. So I think there's just this trend of, we just can't, you know, it's like you don't talk about Bruno, you don't talk about race. And so there's that trend. And I think there's also the other trend, and it's not necessarily a trend, but it's something for us to think about as a result of this, which is, why is strict scrutiny applied to a benign racial identification in the same way that racial discrimination against groups intended to be protected by the Equal Protection Clause are, it's the same standards imposed across the two of them. So, you know, other cases sort of expand this from the time of Bakke in 1978 to now in other contexts where the courts just continue to reject or limit the legal use of racial preference programs. And so, like City of Richmond v. Crossan, Adirond Construction, Shelby Marino, we see this sort of limitation. So I think, I know that was a bit of a longer answer, but I promise my ones to be shorter in the future. I just think it's kind of a good layout to see where we start, where we go. And the facts of Bakke are really compelling because I think it also shows this was not a program that was to blow up and make it a 50-50 split or like, you know, everything. It was just small incremental steps. And that too was too much. So I think it's really important to sort of see that history and see where we are now.
Thank you for that history lesson. And it also makes me think, it sounds like people have been saying this a lot about like systems. Sometimes there's a bug and then there's sometimes the feature of the system. And it sounds like the feature of the system is to be racist, and that these cases are trying to push, you know, once there was a opportunities for diversity, the system was like, oh, no, the feature is the racism. And so we are still strategizing around that. So thank you for that. Eri, can you, so folks know there's two cases, right, that are going to the Supreme Court currently. Can you talk to us about the first case, the Students for Fair Admission versus Harvard? How did it end up before the Supreme Court, and what are the petitioners asking for?
Sure. Thank you, Tamara and Demand Justice, for having us here today to create space for this really important conversation. And thank you for everyone for joining us on this evening. So yeah, to your question about how SSFA versus Harvard got here today, I think, you know, everything that David and Nathalia had just talked about and grounding this in the context of the 40-year precedent is so important as we think about the Harvard case, and that this SSFA versus Harvard case is just the latest in the line of many, many challenges that have been brought to, you know, challenge this long established precedent. You know, just in 2016, the court had addressed affirmative action before the Supreme Court and reaffirmed the precedent, saying that race can be considered as one of many factors as long as it's narrowly tailored to achieve a compelling governmental interest in the Fisher case. And in the Fisher case, where the plaintiff was Abigail Fisher, that, you know, behind that lawsuit was Ed Bloom, who is an anti-civil rights activist, who's also behind the Shelby County versus Holder case that effectively gutted the Voting Rights Act in 2013. And so Students for Fair Admissions is Ed Bloom's organization that brought this case against Harvard back in 2014, and at the same time, they sued University of North Carolina, and I think David can perhaps talk more about that case. But in this case against Harvard, Students for Fair Admission alleged that the Harvard's admissions policy violated Title VI of the Civil Rights Act and intentionally discriminated against Asian American applicants. In this case, the court held 3 weeks of extensive trial, and the court thoroughly reviewed the evidence and issued a really lengthy and thorough opinion reviewing all of the evidence. And as David talked about earlier, Asian Americans Advancing Justice, as well as the Lawyers Committee, represent a group of student amici who were granted special amici plus status in this case, and presented really important and rich testimony before the court, describing their experiences as students, as applicants, and why consideration of race as one of many factors allowed them to really tell their full stories in their applications, and why diversity was so important in their college experiences. And so in this case, the trial court, rejected all of SSFA's allegations that their admissions policy was discriminatory and violating Title VI of the Civil Rights Act. And then, from there, the appellate court reviewed, all of the findings of the trial court and affirmed once again that Harvard's policy and its limited consideration of race for the purposes of achieving diversity passed constitutional muster under the longstanding precedent.
Thank you for that, that background. And you started, I think, to answer the next question I have for you is because I know that your organization is representing students of color, including Asian American students, to support the Harvard admissions policy. Has anything changed in your response now that the case is in front of the Supreme Court? And given the recent surge in anti-Asian American or anti-Asian violence in general in this country, do you think that the argument is particularly harmful at this moment that the other side has presented?
Yeah, thank you for asking that question. This case is part of a really dangerous trend that we're seeing, in which organizations like Students for Fair Admissions are making arguments that policies that are intended to expand opportunities for all students are discriminatory against Asian American students, when in fact Asian Americans benefit from affirmative action policies, both in terms of reaping the educational benefits of diversity that David and Nathalia talked about earlier, as well as from their consideration of their whole person in their application. And so this argument that somehow race conscious admissions is discriminatory towards Asian Americans is actually perpetuating a really dangerous stereotype that Asian Americans are a monolith, that we are a model minority. And this, really obscures the rich diversity of the Asian American community, which includes, students and families from all kinds of immigration backgrounds, refugee backgrounds, ethnic diversity, language diversity. And so, and also like socioeconomic status and a whole host of factors. And by, arguing that this policy blanketly discriminates against Asian Americans really erases that rich diversity and the lived experiences of students that they bring forward. And so, our clients were really a testament to this in their testimony at trial, talking about how, their immigration and other family backgrounds, their obstacles with language and learning English, or their backgrounds with their socioeconomic status. And the fact that they were able to talk about those experiences in their college application essays and really tell their stories was a way in which they can actually present their whole lived experiences and provide important context for the academic potential in their applications. And so, it's really important to remember that the Asian American community is so richly diverse, and that this community stands to benefit from affirmative action policies. And in fact, surveys show that about 70% of Asian American voters actually support these policies. And so, I think there's a lot of perhaps misinformation and misunderstanding about the rhetoric behind this case. So it's really important to remember that these policies stand to benefit so many people.
Thank you for that. I think that's so important to understand the diversity of the communities that are being represented, and that, the strategy to play into the model minority, the monolith, just upholds the system, right? Or then it erases the diversity and the richness, and it makes other people, the dominant culture, feel more comfortable. But this is about us building community together. So thank you for that. David, so there's another case before the court, Students for Fair Admissions versus the University of North Carolina. Can you tell us a bit about that case? I know, I think Nathalia had mentioned it as well.
Yeah, this case was filed on the same day as the Harvard case on Brown v. Board's anniversary. Surprise, surprise, Ed Blum, the #1 enemy of equal opportunity, especially for, people of color, created the organization Students for Fair Admissions, funded the organization primarily to bring these lawsuits because the Fisher v. Texas lawsuit, which he had also been behind supporting, and actually claims attorney-client privilege of his communications with Ms. Fisher, even though he's not an attorney, because of his close relationship there. But now has the Students for Fair Admissions organization that where he's the president, and then Abigail Fisher, the plaintiff in the Fisher v. Texas case, is the I think the vice president, and then her father, Richard Fisher. So they have 3 of the 5 board seats on this. So when you wonder how and why and where, all this misinformation comes, especially about the Asian American community, is because their own tactic is to try and use, that community as pawns and to spout as much misinformation. They do a lot of misinformation about this lawsuit, about these lawsuits as well. So, there's a lot more differences between UNC and Harvard, not necessarily on the merits of the cases, but there are some real key differences in the claims. I'll first talk about some of the similarities. So similarities is that, 1, they were filed by the same organization, right? 2 is that they both bring claims that that the universities haven't exhausted race-neutral alternatives that are available and feasible. And they also allege that race is used as more than a plus factor in violation of Grutter. But they also bring a claim that race-conscious admissions should be eliminated altogether, right? So those are similar claims: race-neutral alternative, race used as more than a plus factor, and the elimination of race considerations altogether. How they different? There's no claim that Asian Americans are intentionally discriminated against vis-a-vis white students or vis-a-vis other students outside of the strict scrutiny framework. They didn't identify, at least in their original complaint, any Asian American students. They just identified 1 white student that allows them to get over associational standing. We found out in the Texas case exactly a little bit more, because we represent interveners in that case and doing discovery a little bit more about the intricacies of that organization and how they fish those students off the internet. But getting past that, there's no intentional discrimination claim, and there's no racial balancing claim. There's no claim that they're, essentially trying to racial balance, the percent of Black students. So they had mentioned it in their petition for cert, and we're like, you didn't even bring a racial balancing claim, but that's, where they wanted to go. But they're also different because context matters. What works at Harvard, what works in Michigan and California and other universities doesn't necessarily work at UNC. And this is one thing that, the courts have recognized. Justice O'Connor in the Grutter decision recognized the importance of context and about how, each individual student, at university will have to satisfy, strict scrutiny and taking into account, different factors that implicate the use of race there. But it's especially important when you look at UNC's unique history, right? UNC is in the South, right? The South. And we had, submitted an expert report because we represent interveners in this case with the North Carolina Justice Center and our partners at Relman Colfax. We were able to submit expert reports in this case. So we submitted the expert report of a history expert who talked about the segregation, not just in North Carolina, but more specifically in UNC. And so they have this history of exclusion that has folded over, and that history doesn't stand in isolation either, because we had students and alumni, witnesses and clients who testified in the case about the challenges that were unfolding still in the 70s, students who had went to segregated schools or only recently desegregated schools in elementary, junior high, and high school. Now, all of a sudden, they're going to the university thinking, well, this is going to be a great place, to learn, but there's a lot of remnants, vestiges of discrimination, still lingering there. But even today, you fast forward, 40 years from then, and we had really powerful testimony from our student clients. Some of them were talking about how, they still walk the halls on and walk the paths on at the UNC campus with this racist graffiti, on the walls, the names of former slaveholders, the names of former segregationists on, those buildings, and that's what they, have to face, every day. There's other students, who talked about going to parties, and told that they couldn't go because they weren't allowing descendants of slaves. This is actual sworn, unrebutted, testimony from these students, because we talk about these things oftentimes distancing ourselves, from the personal stories, but we have that in this case, and we have that also in the Harvard case, as Eri had explained. And it's a state flagship also, right? So it's not a private university like Harvard that recruits from all around the country. It actually has, I think it's an 82% cap on where you have to have at least 82% of your students from in the state of North Carolina attend. So that, plays a factor as well. And I do want to mention, that the powerful testimony that we received from our student clients, these are people putting their names out there, putting their faces out there in these really hot button issues, with these cases. Andrew, Cecilia, Luis, Laura, and Star, that's their names, of our clients in these cases. And they, along with other witnesses, testified about how, this whole preparation for the 21st century workforce, is working in part because North Carolina still has many challenges. It still has very low enrollment rates of Black students and Latinx students and Indigenous students and certain Asian American, underrepresented Asian American students. So, all that testimony, it was presented in a 2-week trial. UNC presented a lot of administrators and experts. We presented 8 fact witnesses along with 2 expert reports. It was during COVID, so we had an opportunity to submit the expert reports in lieu of, their testimony. And what I will say is, in these cases where the court rejected, all the claims of SFFA, and it didn't help itself because it put on one hell of a weak case. I'm not saying that because we were on the other side. I'm not saying that because, we or UNC's counsel destroyed their witnesses, which UNC's counsel did destroy, their witnesses, but they put on two witnesses, two experts, the same two experts who had testified in the Harvard case were the only ones. There were no students who testified, no administrators who testified, nobody else testified for them. They called one UNC administrator, and that was it. And that shows, that very well they were hoping that a court, the Supreme Court, would pick this up because what they're really after is to, eliminate the consideration of race altogether in admissions. So I think it's, like the Harvard opinion, I would say, don't tell Harvard this, but I would say the UNC opinion is even stronger than the Harvard opinion, because there was some really questionable tactics that their expert used, lowering the average scores in their own databases for students of color, because they were supposed to use a conversion chart of converting SAT or ACT scores to SAT scores. But instead of doing that, they just automatically said, well, here's the average Hispanic score, so we're going to lower it. Here's the average Black score, so we're going to lower it. And this UNC's expert showed that these flaws were significant and pronounced. And that case actually skipped the Court of Appeals, the Fourth Circuit. It went to the Fourth Circuit. Then they sought cert like the very next day. There was no reason for the court to grant cert, in Harvard, much less, UNC. And we fought it, vigorously, but unfortunately, the court granted cert, but that doesn't mean, we're going to stop here. We're going to go down swinging. We know that the cards are stacked against us and our clients. But like I said, we're going to go down swinging like hell because opportunity matters, and it still matters, especially with race.
Thank you so much for that breakdown. And I think this kind of leads into the next question for you, David. You've met at the end, you were talking about how they offered cert, they granted cert, and skip processes, basically skip some steps in this normal process. And we're seeing this more and more with this particular court, this iteration of the Supreme Court. Could you just explain a little bit more for the audience what this really means in the process, in terms of like process and procedure normally when it comes to a case within the court system?
Yeah, and so, this could definitely be, its own discussion, and I'll try to, truncate, everything. But I think, when you think of stare decisis, of course, what does it translate to? To stand by things decided, right? Adhering to precedent. Why is that important? Because it provides consistency, transparency, it helps build trust in our democracy, and Rehnquist said, years ago, that's the preferred course of the court, because it is even-handed and predictable and consistent, development of legal principles, which fosters reliance on judicial decisions and faith in integrity in the courts, right? Those are all sound principles. But that doesn't mean that no decision should be reversed, right? We know not infamously, but famously, the Brown v. Board decision, overturned Plessy for all the good reasons stated there. They didn't necessarily use, a doctrinal, framework for that, but, based on the evidence in that case and the arguments around stigma, et cetera, the court felt that, Plessy shouldn't stand anymore, that racial segregation had no place in our public education system, at least not intentional discrimination, right? Overruling the Korematsu case, was incredibly important. It was a very wrong decision in the 1940s. And they finally, overruled that. The Ramos versus Louisiana case, the case that went to the Supreme Court just a couple of years ago, overturning its prior precedent, revisiting the case on whether or not a unanimous jury verdict is required to criminally convict, someone And so that needed to be, revisited for all the reasons. And this Ramos framework, that I believe it was Kavanaugh that created, this framework, borrowing from a couple of others, but, trying to determine, one, whether the prior decision is grievously wrong, two, whether there are negative consequences, that have flowed from that. And three, unduly upsetting reliance interests. So how many people are relying on this, right? So all of these things that you would think, what you may have read, about Roe v. Wade, you're like, okay, well, why is Roe v. Wade going to be overturned? Well, they've rewritten history on it. And I think that's what SFFA is trying to do here. Nathalia talked a little bit about, the history, behind the Grutter decision already, but recognizing, that schools, still struggled in admitting historically marginalized and underrepresented students of color. Happened then in Grutter, and it still continues, to happen today. The tremendous academic and social benefits that can flow from a more diverse student body occurred then. The research is now even more robust today. So how or why, should we be overturning this? We have universities that have relied on the strict scrutiny framework, and it's proven to work. How do we know that? Because the Grutter and Gratz cases were decided by the same court, through different arguments, but they were set, on the same day. And they struck down Gratz, saying, no, you can't add, 20 bonus points, for students of color. But they looked at, the University of Michigan Law School's admissions plan, where it looked at students, holistically, where race wasn't playing a predominant factor. And so we know it works. We know in Fisher that, there were all sorts of claims, by the plaintiff in that case, but they didn't prove their case. They just lost on the merits. That's what happens every day. And for them to suggest, well, what's even more upsetting and angry, and we have lots of reasons to be angry, and I'm okay with it. I heard someone say that, on Twitter. I was like, if you're angry, it's okay to be angry, because there's a lot to be angry about, today. But what's really upsetting is that they're trying to turn Brown v. Board on its head and say Brown v. Board outlawed, racial segregation, period. And we need to outlaw racial segregation. No, Brown v. Board actually promoted integration. It stopped exclusion. It used and relied upon the Equal Protection Clause, for those purposes. And so to suggest that, this decision is grievously wrong because, otherwise, Plessy would be right, is just so disingenuous. I mean, it's, beyond a law school question. We're in the real world, and there are severe consequences. I think Eri's walked through, some of those today. So, appreciate the opportunity and the great question there. It's going to be, I will say, using this Ramos framework, it's going to be tough because of who we have to persuade. We have to persuade at least 2 of 6 justices having faith in a few, but we have to persuade 2 of those other justices. And it's definitely an uphill climb.
Thank you for that breakdown. I think it's a good reminder that the courts are political, that these are strategic decisions that parties play because of their political wills and desires, and it's working, or we're seeing how it's working out. So we have a couple minutes with us still. We have about 9 minutes. I don't do math. More than 9, maybe 10. And so I want to ask a couple more questions, and then there's a question in the chat, a couple of questions in the chat I want to get to. So I'm going to jump around a bit, panelists. I know that you are prepped, but I'm going to do a little rapid fire. Nathalia, could you just tell us what's possible, or the possible outcomes of this case? And then how do these cases impact beyond the issue of affirmative action in higher education? Could they impact other policies that implicate race and ethnicity?
So yeah, happy to. I feel like actually some of this question has been answered a bit. We've spoken a bit about it. So I mean, you win, you lose, or you get something in the middle. So I think one of the most concerning things could be that diversity is no longer considered a compelling government interest in higher education, and the exclusion of race in consideration in higher education. So completely at all. And I think, I know that Eri referred to this earlier, but really the erasure of lived experiences of people of color in the classroom, a loss of diversity, a lack of cultural competencies, students' loss of sense of community, racial isolation, loss of participation, and like really silencing students who are in the classroom. And I think included in that is, something that is like this reduced standard for critical thinking. If you're in a class, if you're in a classroom and the only thing that's allowed to be taught, and you're never really supposed to mention race, it's sort of like part of how you bring history to life, and how our different perspectives allow people to talk about what history has done, how it continues. And I think I would be much more intimidated to bring up my perspective in the classroom had this been the atmosphere. Not to mention that I was already probably pretty intimidated. But I think there's that, and then of course loss of perspectives. And then to your other questions, we can hope that it won't have impact beyond, but I think we see that there, the push for colorblindness is beyond the affirmative action realm. And so if we can't talk about race and admissions, should we stop worrying about diversity in the workplace? Should we stop worrying about it in housing? If I'm in the housing context, and does that mean that I can't allege or I can't bring it up unless I can show? And I think this is the other trend that's sort of out there, which is unless I can show intent, because it seems to be that the only way that you can prove any level of racism to people is if you have that massive bombshell of a word or some sort of racial discrimination that's so egregious that people are like, oh, that is bad. Despite the fact that we're seeing an uptick in hate crimes, despite the fact that we're seeing an uptick of mass killings of people of color, with the intent behind it. And all of that is happening behind us, but we can't talk about race. So yeah, I hope that answers your questions.
That does. Thank you for that. I think you said this earlier, this push for a colorblind society, whatever colorblind really means, which to me, I think for most of us is like, it means the erasure of who we are and what makes us unique and dynamic, and actually creates the fabric of this country. As cheesy as that sounds, like we are not colorblind at all. We never have been. So thank you for that. Eri, excuse me, are there ways that schools and students can be active in this fight to protect diversity in education right now?
Yeah, thank you for that question. I think it's so important that we don't lose sight that students are at the heart of all this. And I think some of the examples that David gave earlier really illustrate how powerful student stories are. And especially, not only in the legal case, as sworn testimony in both the Harvard and UNC cases, but also that every student's story matters and every student has a voice to share. And I think this is true for both, alumni, current college students, high school students, all students have unique, individualized lived experiences and stories to share. And that, this is beyond sort of the Harvard and UNC cases that are currently before the Supreme Court. And so much is at stake. And, with all of the misinformation that's being intentionally put out there, these stories are so powerful in telling your friends, your families, your community about why these policies that are designed to expand opportunities for everyone matter. And that I think students have such a powerful voice and perspective to share. And I think it's important for them to feel empowered to be able to speak up and share their voices and stories.
Thank you for that. I think that's so important, especially when you describe the student group at Harvard, for instance, that is making the claim. Others are probably, if you hear that, I know that if I heard that for the first time, I'd be like, that's not true, but not knowing what I can do with that truth, right? That, like, how do I help build the argument against that, right? To share and adding data to the experiences that we have. So I want to thank you all again. You've answered all the questions I had and some, and I feel the same for probably our audience as well. I think this is such an important conversation, and someone even in the chat said that they didn't even know that this was happening. And so this is why we do these digital roundtables, and I'm just really thankful that you all gave us the time this evening to really share the work that you're leading and doing and offering us some insight, and also what we can do to help and support to make sure we protect these decisions and these policies, because they do make our country better. They make our communities better. They make our schools better. They make us better people. And that we have to see behind the smoke and mirrors, but the heart of what they're trying to do, which is dismantle the policies that for generations we have been fighting for just equity and justice in this country. So I also want to thank our audience this evening. Thank you for putting questions in the chat. And also, in closing, is there anything that you all would like to share with the audience? Is there places where people can reach you? Is there actions that they can take immediately to support these cases? And then we can close it out.
I did put in the chat, my email. Certainly, if you know any of us, we can put you in touch with the amici group, if that's what you're interested in, whether you want to sign on to an amicus brief. There's lots of amicus briefs, and of course we want that kind of support, but at the same time, clerks aren't going to read 150 amicus briefs, right? So we're trying to bring people together as much as possible. I think that's incredibly important. And I do want to say that as important as affirmative action is, because I think it is, it's just one of those principled pieces, and knowing how systems operate against people of color, it remains so incredibly important. But affirmative action is only one piece of racial equity in higher education, and there's so much more. And there's only not just a handful, but a few dozen universities perhaps that are engaging in affirmative action because they have to. But there's so much more around recruitment, so much more that alumni can do to raise these issues. We're doing some of that work at Lawyers Committee in Illinois and Ohio, trying to work with specific universities, state flagships there. But it's a lot of work, and I just want to stress that it's so incredibly important that racial equity is addressed through comprehensive policies and practices, that are fair and meaningful. And we need to know that, not just now, but even after, when it might become even more important, next June.
Thank you so much for that. Well, with that, I want to close this out. Thank you all again for joining us this evening and for having this great conversation. It's sobering, but necessary, but still there's a little bit of hope and light in this, because we always will keep fighting. This is not the first time we've been here, unfortunately. It won't be the last, but that's what makes us our ancestors' wildest dreams, I feel. So thank you all so much, and have a great evening. And thanks to everyone for joining us at home.